Again, thank you for joining us, folks. This is Eric Howgame, Executive Director of Homeline, and you're joining us on Wednesday, July 29th at 1:30 for our weekly webinar on COVID-19 related tenant-landlord issues in Minnesota. Again, we've been doing these for a while now. I'll talk about that in a minute. There we go. So just a reminder about what Homeline is. We're a statewide nonprofit that provides free legal advice and information for renters throughout the state. And our program is free and confidential, and we advise renters about their rights in English, Spanish, Somali, and Hmong languages. You can give us a call on our hotline or contact us via email. We've been doing these webinars since about mid-April, and they're all available on our website. Next week, we are going to be doing another one. We've kind of transitioned from 2 weekly webinars into just a single webinar on Wednesday afternoons, up to 90 minutes if we take the whole time, for both an audience of tenants, landlords, service providers, and others. And again, we'll be covering sort of in more detail the new executive order that changes some of the aspects of the eviction suspension, and that goes into effect next Tuesday. So this will be the day after it goes into effect. And you can register for our webinars on our website. We also have a number of new pieces of material on our website that Mike might go through as we talk about some of the COVID-19 related issues. But all this is available on the COVID-19 tab on our website, homelinemn.org. You can register for next week's webinar. You can view all of our, any of the past webinars since April that were recorded, and also a number of FAQs on different issues related to the pandemic, such as the new eviction suspension order and the mask policy, et cetera. So with that, I'm going to hand it over to Mike. Again, this week we have a special guest speaker, landlord attorney Kim Tennyson, and so I'll hand it over to Mike, Homeline's managing attorney and hotline director.
Thanks, Eric. And how this is going to go today is we've got 20 or 30 minutes of material to cover, and then we're going to do what I'm really looking forward to, talk to Kim about some of her views as a landlord attorney going into the future of evictions, the very near future of evictions when the courts finally open up again. Eric just mentioned a couple of items. If you could go back a screen, Eric, thanks. The FAQ on masks is a new FAQ that we've put up, and I'm guessing Eric will put that in the chat box because he's really fast with that chat box usage. We put that together a couple days ago in response to the mask executive order that went into effect on Saturday. And so you can see what we think that means for landlords and tenants in a, like I said, a brief FAQ. All right, and then on to the next slide, Eric, thank you. Okay, so once again, here's where we are. And Eric pointed this out last week. For those of you that tune in every week, we should change this to 4 times already. The governor has renewed the executive order extending the peacetime emergency a 4th time. We're going into August. It runs through August 12th. And during the peacetime emergency declaration, a landlord is effectively stopped from filing almost all the evictions. As we've talked about every week, almost every eviction in Minnesota, well over 90%, is filed for non-payment of rent. And those evictions simply aren't fileable right now. At the earliest, they would be fileable on August 13th. That's presuming that there's no extension of the peacetime emergency. As we've talked about before, the governor or the legislature, and that would be both chambers of the Minnesota legislature, would have to vote to end the peacetime emergency declaration. So either the governor can stop it or the legislature, if both the Democrat-controlled House and the Republican-controlled Senate vote to end the peacetime emergency declaration. The last 2 times when they've had a chance to vote on these things, the Republican-controlled Senate has voted to end the peacetime emergency declaration. The Democrat-controlled House has voted not to, so it remains in place. By the way, it's not just about evictions, the peacetime emergency declaration. There's a whole bunch of other powers and or benefits to having the peacetime emergency declaration from the governor's perspective that extend well beyond evictions, but evictions certainly are a key component. The other hurdle that we've had in place since March is the federal ban on evictions found in what's called the CARES Act. This effectively ended a couple of days ago, the CARES Act moratorium on evictions. It's I think, impossible to know what's going to happen at the federal level, whether there's going to be a renewal of that with some sort of gap in time. Obviously, today is the 29th of July, so they can't extend that July 25th deadline from July 25th. They'd have to do it from July 29th if they were to enact something today, which isn't going to happen in one day. But anyhow, that CARES Act, federal prohibition on evictions, in a large part in Minnesota, doesn't matter that July 25th happened because we still have the state moratorium in place. There are several states throughout the country where the CARES Act expiration is a huge story, a huge deal when it comes to evictions. But in Minnesota, because the Minnesota state eviction moratorium is still in place, the July 25th isn't anywhere near as impactful. There is one other key element, though, of the CARES Act, which is that there's a requirement of a 30-day notice given by the landlord. So as we understand it, that will extend. So let's say that the governor, Minnesota governor, ends the eviction moratorium on August 12th. Then on August 13th, if a landlord has a property that's governed by the CARES Act, which again, 20 to 50% of Minnesota rentals are best guess, then they would have to give a 30-day notice under the CARES Act in order to file an eviction against the tenant. So that means, I guess we're looking at September 11th or 12th would be the first day the landlord could file an eviction if the Minnesota moratorium is lifted, which is, again, a big if. One of the questions we're asked every day on our tenant hotline, where we get 15,000 calls a year, and I can't remember, I know we're well over 2,000 COVID-related calls now through the year. But we're asked constantly, is the governor going to renew another peacetime emergency declaration? And the short answer is we really don't know. We don't. We have no real firm idea. We have suspicions, beliefs, but it's gossip, and we acknowledge it as such. We have no firm commitment. It could be that the governor is waiting until the last minute, looking at the statistics, how many people have contracted COVID-19 recently, how many fatalities there have been recently, and making a decision at that point. Or maybe the governor has a plan to keep this in place for the entire calendar year. It's unknown. As near as I know, there's been no official declaration by anybody with the ability to make that declaration. The governor can only extend these 30 days at a time under the peacetime emergency rules. So if you're thinking, well, why does the governor keep us all in suspense? That's because they don't have a choice. The governor has no choice. If he wants to continue to extend the peacetime emergency, that's the only mechanism in place for doing so, is 30 days at a time. Okay, if we could go on to the next slide, please. Okay, this is a summary. We went through this in depth last week, the changes that are going to take effect August 4th. And we've gotten some clarification from some of the authorities on some of this stuff, but most of it is still, this is a pretty accurate summary of what we know, the 2079 executive order. That's what that's referring to. Whenever you see that EO, executive order, 20, that's 2020, 79, that's the 79th executive order that the governor's given. Anyhow, 20-79, the changes it makes to the eviction order are, first of all, there's more reasons for a landlord to be able to file an eviction. I think the two that matter the most are that a landlord can, on August 4th, file an eviction for serious damage to the property or substantial damage to the property. And also they can want to move in on their own or have a family member move in. These are the two new exceptions to the eviction moratorium that, again, take place on August 4th. Additionally, the new order makes it, a question we've been asking since the original order was put in place in March was whether a landlord could non-renew a lease for a date after the eviction moratorium deadline, the current one, was extended. So to use it today as an example, can a landlord give a notice in a month-to-month lease where normally pre-COVID-19 times, if they wanted to give the proper notice, it would be in writing and they would tell the tenant to leave by the end of August because it's still in July. We're in the July rental period. Now, a landlord, our theory has been all along, because of how the wording of the original eviction order was that a landlord could not terminate the lease in that manner. But the August 4th 20-79 clarifies that and says that a landlord can't give a non-renewal as well. So it really does answer a question we've been guessing we thought we had the right answer to for months, but now it's more or less confirmed. There's also an additional new notice requirement before, as near as we can tell, any eviction is filed. So it's at least 7 days. It might be longer depending on what the lease might say, which is a pretty confusing concept. You'll have to trust me on this one. I walked through it a little bit last week, but notice requirements and leases, if you find them, are usually about the end of the lease. And so the question is whether that's what this is referring to or not. The order is pretty vague, and it's hard to figure out exactly what the governor meant by that. We have sent a list of questions / clarification requests to the governor's office. I think it's been about a week now, and haven't heard back or seen any FAQs resolving those questions. We'd love to see that, but to date, it hasn't happened. Again, that order doesn't really take effect till August 4th. So we'll know more either by the governor giving an order or by courts making decisions on what this means within the next 3 weeks, I would imagine. And the last big change that happens on August 4th is there were some writs. So a writ is the piece of paper that a landlord can win in an eviction hearing. So a writ of recovery of the premises is what we're talking about here. Many landlords had already filed cases back in March, and they have a writ that was issued, but they never executed it to the point where the tenant was ultimately removed, which is the final step of an eviction process, is the sheriff enforces the writ. So there's these old sort of March writs that are hanging out there, and this order from the governor, lack of a better way to phrase this, tried to resuscitate those writs through the governor's executive order and reinstate their meaningfulness. And again, we'll talk about this more next week, and we talked about it last week, but that's a summary of those changes. And I wanted to talk about them because they're still not really the rules yet. They're going to be the rules next week. We just got quite a bit of advance notice of them, which is unusual for what we're going through since March happened. All right, if we could go on to the next slide, please, Eric. By the way, I'm going to be done with this portion of the presentation where I talk fairly soon. And then Kim and I are going to be talking, but we do want your questions. We have one submitted in advance. We have one already submitted today, but we like to hear from people what they're asking about, what they want to know. And today we have a landlord attorney, which is a first for us here. And so we want to hear, especially if there are landlords out there with questions, you'll have a chance to hear somebody that's not a tenant attorney. If you think that I'm somehow giving completely biased answers, then well, maybe Kim will give equally biased answers in the other direction. Although I don't like to think of my answers as biased, and I'm sure neither does she. So the last one, new change to the law that I'll talk about from the COVID-19 perspective is the mask requirement. Again, we have an FAQ that we've just put on our website about the mask requirement. But the changes that it makes that I think matter for landlord-tenant, that arena, is masks are now required in common spaces. There is a FAQ put out that Eric just posted that essentially is answering that question. Does that mean the hallway? Does that mean the lobby where mail is? So do tenants need to actually put on their mask the minute they leave their rental unit in a multi-unit building? And I think the answer is yes, based on what we've seen in that FAQ. Landlords and agents must wear masks when they're entering the rental unit. Which was, I think, the best practice for every landlord since March. But you'll have to trust us that we've taken plenty of calls from tenants around the state that said that the landlord, their employees, the person doing maintenance wasn't wearing a mask when they came into their place. So this gives a tenant something to point to that definitively says that the landlord or their agents must wear masks. The last key part is many cities had adopted mask requirements prior to the governor's order. And those requirements are still in place. And if there's more requirements there, the governor's not chipping away at any of that. They're saying whatever the most stringent requirements are, the state executive order or the city rule are the ones that all the citizens have to follow. So if you're in a city that happens to have one of those mask rules that was in place, then you have to abide by that, not just the governor's order. Okay. On to the breaking news. So when we set this up last week, what we were going to talk about today, we didn't realize when we had scheduled this that the Supreme Court was going to be issuing a decision in a landlord-tenant case. We don't get Supreme Court landlord-tenant cases very often in Minnesota. It just doesn't happen. When I say Supreme Court, by the way, I mean the Minnesota Supreme Court, the state Supreme Court. So today we got the decision in the Section 8 case, as most people call it in our trade. Fletcher, there's more words there, but Fletcher versus Minneapolis. So what we had was a city ordinance passed by the city of Minneapolis that I want to say was put in place, wow, maybe May of 2018. It might have been 2018, might have been that long ago, might even be longer ago. Anyhow, it was a bit ago. And a group of landlords didn't like this ordinance. What the ordinance did was it effectively made Section 8 and other types of housing subsidies a new additional protected class in the city of Minneapolis. So a tenant could effectively say, I'm being discriminated against because I have a Section 8 voucher, and you can't hold that against me. And a group of landlords challenged that ordinance and said this is unconstitutional on quite a few different grounds. And it was hearing at the district court level, so that's the first court it was in, where a summary judgment motion was made. And the landlords prevailed at the district court level. Now, what happens in a summary judgment situation is it's not a final decision on a case. Summary judgment happens early on in the actual case itself. So it's not like a judge ruled with their gavel, this is the final answer in this entire case. They were asked to rule on a specific portion, a legal portion of the case. And the judge made a summary judgment ruling on the case, basically saying, you know what, landlords, I agree with you. That ordinance is unconstitutional for a few different reasons. And so I agree with you, and that's it. And then the city appealed the case, and that case went to the Minnesota Court of Appeals. Court of Appeals looked at the case and said, landlord, we don't agree. We think the city had the right to do this. I'm summarizing, of course. That's not exactly a quote from the Court of Appeals. And then today we got the Supreme Court decision, which affirmed unanimously the Court of Appeals ruling, which said that the city's ordinance withstands legal scrutiny under these two key questions, the due process question and the equal protection question, both questions under the state Constitution, not the federal Constitution. There are a couple of issues that are still unresolved that weren't addressed by the initial court, and so they didn't get appealed and battled over in the Court of Appeals and the Supreme Court. So the case is effectively sent back to the district court. So what happens is that original case, it was heard by that judge. The judge ruled in favor of the landlords, and so that effectively ended the case at that point. But now that ruling has been overturned. So it's like the judge's ruling never really occurred as far as that case goes. I know it's a little bit complicated, and I'm trying to boil it down in a way that's not insulting to you, but it still is saying this correctly. But now it goes back to the district court, and then we'll see if the landlords decide to try to challenge any other parts of the ordinance. I'm not sure what they'll do. I think that they probably don't know what they'll do. They just got this information this morning. This literally was posted at 10 o'clock this morning. And so we're trying to give you a decent, quick analysis of what the Supreme Court said. And I really don't want to confuse this with any COVID-19 related stuff, because it has absolutely nothing to do with COVID-19 related topics, which is what we've focused on predominantly in these weekly sessions. Although occasionally we've talked about some other things, but this is a big story. We have heard from other cities, certainly around the metro and other parts of the state, that have been simply waiting for this decision to be rendered. And their tentative plan was, if the city prevailed, that they were likely to follow with a similar ordinance. So this is likely to have an impact in other cities. And we saw, I think somewhere, Eric, you can help me out with what Representative Howard had to say, but I think he mentioned that he planned to submit or introduce some legislation at the state level mirroring this ruling. Is that, was that on Twitter that he put that today?
Yeah, Representative Mike Howard, who's vice chair in the House of Reps of the Housing Committee, said good news, and that in 2021 he will introduce legislation to ban this practice, I guess, discrimination against Section 8 across the state. And just a couple of quick notes. Yeah, this was enacted in March of 2018. I think it was set to, or 2017. 2017, March of 2017. I think it was set to go into effect like January or something, or maybe it was July of the following year, and it got sort of put on pause as far as enforcement because of the challenges. So I'm guessing that, and correct me if I'm wrong, and maybe none of us know here, but I don't think the city can start enforcing it now, but maybe they can.
Well, I'm not sure. I tell you what, we'll ask Kim about this in a second. We'll ask her if one of her clients asks about it, what she would advise today based on what she knows. That probably makes sense. So why don't we just jump ahead and I'll introduce Kim and we'll ask her that question to start, and then we'll go into the pre-planned topics. Again, happy to be joined today by attorney Kim Tennyson, who represents landlords and evictions, and I'm sure other cases as well. Kim also does trainings for landlords and their staff, which I certainly I've done a lot of trainings for landlords around the state, and I know that they're always looking for qualified and good trainers, and Kim is certainly one of those folks that can do that. Here's some contact information for her as well. I know that we have landlords that join our sessions, and if you're thinking I need to consult with a landlord attorney, Kim gets my recommendation. She knows what she's doing in this field, and you'll have to trust me, there's a lot of lawyers that the vast majority of lawyers in Minnesota have no idea what they're doing in landlord-tenant law. But Tim actually practices in this field. You really don't want to just go grab some general practitioner for an eviction. If you're a landlord, you want to get somebody that actually does evictions, because look, it isn't rocket science. Maybe there's only 1,000 or 2,000 things to know, but you have to know those 1,000 or 2,000 things. And if you don't, I've been against big landlords that are big lawyers that work at the giant firms that have no idea what they're doing when it comes to landlord-tenant law. You want somebody who actually works in this field and is in the trenches, and she's been in court in every metro county working on evictions. So we're lucky to have her here today. And Kim, I hate to put you on the spot with something that we didn't plan on, but if you get a call from one of your Minneapolis landlord clients right now and they say, hey, wait a second, I've been saying no Section 8 in my ads. Should I take that out of my ads today or not? What do you think you'd be saying?
I think I've always said, don't put that in an ad. You know, what you're looking at behind the scenes is really the qualifications of the tenant, in addition to whether they have a voucher or not. My clients, my current or regular clients, I don't think really object to or restrict Section 8. I haven't heard that sort of thing. It's not been a problem for me. I don't hear complaints about Section 8 tenants, or I got to get rid of this one because it's Section 8, or I don't want to take them because it's Section 8. So I don't know that I can really address the problem situation.
Understood. Yeah, and honestly, I'm not sure how much the problem is right at this moment in time either. We have actually seen an increase in landlords looking for Section 8 tenants since COVID-19 kicked in, for an obvious reason. Tenant has a Section 8 voucher, Uncle Sam's paying a giant chunk of their rent. And that looks like a pretty good promise to a lot of landlords when they have market rate tenants, private market tenants, that aren't paying all of their rent. So we're actually seeing this happen. I've seen this happen once before, right about 2002, where landlords were actively seeking Section 8 voucher holders, and we're starting to see that movement again because they're seen as a more dependable payer than a private market tenant might be. But anyhow, I appreciate your insight into that. But why don't we go into what you were planning to talk about now? So Eric, if you could send us to the next slide. Okay, Kim, I'm going to turn it over to you, and just ask you to cover kind of these points before we talk about some scenarios that your clients might approach you with soon.
Sure. So client concerns, I've actually been surprised at how patient landlord clients have been, or at least were until this last extension. I think everyone was hopeful that a few months would do it. So I'm starting to get more pressure about, well, what is going to happen next? And we'll get into that a little bit, I think, in the next slide is what do we expect? Other than that, I have not heard a whole lot of specifics. I think I probably will have some filings under the newest exception, maybe the current exception related to danger to others or substantial damage to property. I think I have some of that coming up maybe in the next week, but I think most professional landlords are working really hard with their tenants. We've got the Section 8 being paid. They've entered into payment plans with some others, and I think as of a month ago, there was a short list of people who were probably going to be filed on at some point.
So you honestly think you're going to be quite a bit busier a week from today with evictions?
I know that I've got at least a few waiting because they fit with the latest exceptions.
And you mentioned the endangering or the property damage.
The after August
the new rule.
Exception, yeah, the latest exception. I know I have one of those.
So not the family one, but the property one. The family exception.
I might actually have one of those others as well.
Okay.
Those are tough because they're really breach of lease complaints. And those are tricky anyway. It's just honing in on what is that particular breach. And it needs to be established. You can't just say, hey, I think this person threatened somebody. You've got to have something more to it. So that's part of what I've been working on, is trying to make sure that we know that it fits, because
Sure.
that's what the court's going to be looking at.
Fair enough.
So concerns about court process going forward. Okay. So that's mostly what I've been hearing from clients. I'm sort of waiting for when this ends, just like everybody else. So for those waiting on their previous cases, and I think there's a question that was previously submitted on that, we don't have any information either. If it wasn't for Homeline and for referee hoteling speaking last week and some of her ongoing communications with the legal profession, we would know almost nothing. I've not heard from other courts where I had actions sitting there when I got called on March 16th to say, don't come to court.
Can I ask where they were in the process, where these cases were?
I had 3 hearings the week they canceled.
So like March 14th or something?
I think one was the next day. I want to say it was the 17th.
Oh, I see. Okay.
I think we knew that there was a moratorium probably enacted maybe the Friday before. I can't remember.
Okay.
I knew it was coming.
Mm-hmm.
And I think I got a call on a Monday canceling my 3 hearings for that week. A Tuesday, a Wednesday, and a Thursday, I think, in 2 different counties. I've never heard a word. And none of them were Hennepin. I think there were 2 Ramseys and a Dakota. I've never heard a word back. They said, we got to cancel these. We'll contact you in a few weeks, and nothing else. So for anybody who's a landlord wondering what happened with those cases, they are still sitting there. They've got a notation of pandemic event, and someday they will be rescheduled unless they're dismissed.
Yeah, and actually you brought up the question, and I'll just say it out loud because it does fit with what you're talking about right now. This came from Matthew, and here's what he wrote. He's a landlord.
Yeah.
I served a non-renewal of lease at the end of January, notifying the tenant to vacate at the end of February. When they didn't vacate, I filed in court and received a court date of March 20th. 3 days before my case, they closed the courts. My question is, I already have a case pending. How does this fit into the governor's new order? How do I restart the case? I can't get any answers from the housing court. So you're saying, as an attorney, you're not getting any more answers than Matthew's been getting on those kind of limbo cases.
Correct. They're just sitting there, and the court won't answer those questions. Clerks don't answer that. Even if they know the answer, they can't give legal advice. They're there to accept cases and schedule cases, and they're not going to go too far in the advice area. What I think we could have a problem with a notice to vacate is whether the landlord is still collecting rent, because that would waive the notice to vacate.
So you think if Matthew has been collecting rent since March, his case probably has got a waiver issue going on with his notice to vacate anyway?
It's moot, and he would have to start over with a notice after. But if he's now got a non-payment of rent case along with the pending or hold pattern notice to vacate, it'll get heard eventually, is what I've heard.
Do you have so you think the cases that were stopped, like Matthew's and the ones you mentioned, that they will be restarted without the landlord having to file another case, pay another $300 filing fee? You think
Correct.
They're just going to act like the pause button was hit again and the case restarts? That's what you think
my
will
understanding.
happen?
That is my understanding.
Now that is different, of course, from the governor's order where he's talking about writs. In Matthew's case and the cases you brought up, writs, you had not gotten the writs yet.
Correct.
And so it's not like the August 4th order does much for Matthew or for your 3 cases that you brought up.
Right. I actually do have one of those old writs too.
Oh, you do?
In Hennepin, yeah. It was March, I think it was dated March 24th or 25th. It's right in there. I didn't think that they would issue it if it wasn't possible, and they issued it and then said you can't do anything with it.
Right. But now you're going to try something on August 4th with it?
Yeah, next week. And I think it's a matter of requesting an alias writ and getting, because they're only good for 30 days from the time you pull.
Can you describe what an alias writ is for everybody?
It will be asking for a replacement, I think, basically, just something that takes the place of the one that was issued because of the extenuating circumstances. It's not typical.
Have you ever done one before? An alias writ?
I haven't. It's funny, I had a call from an attorney yesterday and he had a different question about kind of what we're talking about today. And he said that he had one of these. It was a commercial eviction and he just got it and was surprised when they said, we have a court hearing for you and you can come to court. And he called and said, can't I do Zoom? And so they said, sure. But there was a notice sent. A notice was sent to the tenant letting them know that there was going to be a hearing on this writ. So it sort of resurrects the whole thing and then creates a reissuance of it. And this was a commercial writ. So the sheriffs were going to be executing that. But that was the first writ case that I had heard of since just hearing about the August 4th order last week.
So Kim, I know you've been watching a lot of these and you've commented on some of them and we've talked about it a little bit. I have expressed concerns about sort of the due process concept of court going forward when they restart because of the massive number of evictions that are backlogged. I'm not talking about the August 4th. I'm talking about August 13th or September 13th, whenever the gates really get opened up again. What are your concerns about courts when they open up again as a landlord attorney?
Well, there's a lot. There's a long list. As the months pass, it's becoming more difficult to envision what will happen. We first started hearing from Hennepin County Housing Court, because it's the only one who's told us anything. We started hearing things probably by April, and we've been updated pretty regularly. And as the only source of information, I know Hennepin County Housing Court is trying to get some processes in place. And they have explained several things, but as simple as it sounds, I think I see several bottlenecks in the process. For example, they have issued, and you must have seen this, and maybe it's something you want to summarize and put online, but there's an order from last week, or July 22nd, from Hennepin County District Court that really elaborates on some of those processes that the referee spoke about. And they have prioritized the cases that they're going to hear. So I'm going a little out of order, but I'm just going to tell you what the priorities are. So the first priority are complaints alleging illegal activity, or under MnSTAT 504B.171, I think.
Which we already kind of have.
We already kind of had that,
yeah.
And they're continuing. So they're hearing those now.
Sure.
Those are expedited cases with expedited writs, I believe. And then second priority are those previously scheduled for an initial appearance and filed prior to March 24th.
Okay, so that's sort of an answer to some of the stuff we've been talking about, yeah.
So, and that's partially where I get that. It's been reiterated. So they do have a stacking of priorities here. Third priority complaints are the ones filed during the peacetime emergency, the moratorium, and didn't qualify as an exception to the executive order, the moratorium.
Right, so these are ones that are filed that are arguably a misdemeanor.
It includes those, but I think it also includes those that are supposed to be an exception, but didn't qualify as an exception on a review by the referee.
Right,
so they're putting them into that pool.
Right.
Those probably have more validity as a breach anyway, but they don't fit the exception. And then, yeah, I think the referee did mention a number of cases that had been filed in violation of the order. And it's questionable what's going to happen with those. If anybody watching is a landlord who filed something thinking that you were going to get in line, get to the front of the line, or just didn't realize there was a moratorium, you probably need to dismiss that case.
Yeah, I think she mentioned, referee hoteling, when she was on a couple weeks ago, mentioned that those were being marked as confidential, which was a term I don't think I've seen used in the court documents before, but that's what they called it. And then when we talked about that, I think she said, if I remember right, that those cases would be reopened long enough to be dismissed, the ones that were filed incorrectly during the COVID-19 moratorium.
Right.
But they have to take that step, apparently.
Yeah, made confidential means that the party names are hidden.
Understood.
You'll be able to search that. So once they're unhidden, now you've got an eviction out there with somebody's name on it, and it was recently filed, so they may end up in the hands of the Attorney General's office.
They might have to file an expungement motion as well. Hard to know.
I think the court, if they're going to dismiss, will expunge. I sort of question whether they'll make the decision to actually dismiss them if they want to preserve them for prosecution.
That's a good point.
Referee hoteling did say, because we double kind of asked the question when she was on, that their plan was to like open it up, have it open for like 7 days so that the parties got notification, and then dismiss it and automatically expunge. So at least in the 4th Judicial District.
I mean, a tenant might be wise to screenshot that, right? And make sure the Attorney General's office can see it.
Probably. And that's why I just recently started thinking about the idea of dismissal. It would benefit the tenant, but it wouldn't necessarily leave something to prosecute the landlord.
That's a good point.
I'm not quite sure.
Sure.
I wondered about that in the last couple of days. That part wasn't clear. She did say dismiss and expunge, though. And then let me see here. Turn the page. Oh, and then the 4th priority is everything new that comes along after the moratorium is lifted. So it's not real high on the list. They'll go in order. I think some of these things will happen contemporaneously at the same time. But that does put those new evictions as a 4th priority.
But the new evictions, I assume it's going to be first come, first served.
That's really how they process.
Right.
Filing electronically, attorneys are required to file electronically. I don't know what they'll do with at-the-counter filings, if they'll be able to even issue a summons at the same time or tell somebody they'll mail it out or come back. That's happened even in pre-pandemic times. But filing electronically, they do put them in a queue. They do try to take them in order. Somebody hand reviews those upon acceptance. So it's not just push a button and it's in. We have to wait until it's accepted. And accepted doesn't mean it's validated. It just means they're accepting the filing for scheduling. And then they'll issue the summons. That part is, I think, the same as before, but I don't know what happens if there are 500 cases a day in that first week. That's a lot. I mean, it's going to take them a while to hear these. One of the other things in the process is, besides taking a while to hear these, there are some other changes that have occurred. They've lightened up or relaxed some of those statutes of limitations so the court can work with their timing. And I think that could push it out a little bit further. So we're not looking at filing and being in court in 2 weeks or 3 weeks. Effective August 4th, I don't know if you talked about this one, but effective August 4th, there is the 7-day notice prior to filing an eviction.
Right.
So assuming that even if this was lifted, now they have to wait. You have to do a pre-notice of eviction of 7 days. And then more specific, or also specific to Hennepin County, is this new 7-day adjournment. I would think Ramsey County might be in a similar situation, haven't heard from them. But the 7-day adjournment has been made more clear as well, that it's going to be, if you don't come into your preliminary eviction hearing with a settlement agreement, or you can't come to some terms very quickly, we have about 15 minutes, it's going to be adjourned for 7 days while the tenant can seek legal advice through VLN or legal aid. So there's these extra stops along the way that are going to lengthen that already long process. And again, I don't know where that bottleneck occurs in there. Is it in getting those summons out and the scheduling done? Is it in trying to get everybody in 7 days at a time? I guess we'll see. It sounds simple enough, but I think depending on the load of filings, it could be kind of messy. So that's why my first thought is landlords really need to be reaching out to tenants and vice versa to try to settle things sooner rather than later. Maybe you want to do the next. Do you want to do the next slide?
Sure, we can go through the
Yeah.
scenarios here that we've talked about. And once again, just for those of you that are joining late, or again, we have a lot of people to watch these later on. These get recorded, and Eric will make those available. Today's July 29th, 2020. We're talking to Kim Tennyson, who's an attorney that represents landlords. And we've come up with a couple scenarios to talk about. We're going in forward in time here. We're looking at whenever the moratorium is lifted. We don't know when that'll be. But the moratorium, the state moratorium has been lifted. And here with example one, we have a tenant who we always use $1,000 in rent because it's just easy math. That's their rent. They haven't paid rent at all since March. I mean, March, mid to late March was when the moratorium got put in place. So they probably paid their March rent. They lost their job and they haven't paid their rent, whether they got any supplemental money through unemployment or the $1,200 federal subsidy. And they haven't paid the landlord at all. So they're $5,000 behind. Let's just assume that Governor Walz lifts the moratorium on August 12th, August 13th, the landlord is eligible to go file. We'll ignore the CARES Act for a second. We'll just assume that that doesn't matter here. So we've got a tenant that's $5,000 behind. Your client calls you up and says, hey, they're $5,000 behind. Let's get going. What do you do at that point as a landlord lawyer?
Well, for the people, and I think 1,000, I know it's a made up number, but I think that 5,000 is probably going to be a lot more for a lot of people.
Oh yeah, because 1,000 is a low number for a lot of rent. You're right.
Yeah.
Could be 7,500, could be 10,000, sure.
It could. And just as with any time, when you start accumulating rent that way, it makes it sort of unmotivates the tenant. Where are they going to get that money? I think it's important here to maybe triage the cases and figure out who owes the most and what you're going to do with those versus the ones that are just a little delinquent. And I know we're coming up on that. I would reach out, or I would tell the landlord to reach out and talk with the tenant and let them know, hey, this moratorium is lifted. I'd like to talk to you about what your plan is, because I am going to be proceeding with an eviction. And just note, I would not threaten any eviction now. I wouldn't really bring that.
You mean today?
Yeah, today.
I'm talking about, though, again,
But
August 13th, the moratorium's gone, yeah.
When it's lifted, then I would say, let's have this conversation. Talk about what will work. Do you want to move? Have those things in place before you get to court, because normally when we get to a court hearing at the courthouse, we can sit nice and close and we can discuss for half an hour.
Not these days, we can't sit nice and close.
We won't be able to do that. Not only will we not be sitting close, we'll probably be in a Zoom meeting with about 15 minutes. And that's where that 7-day adjournment will come in. If there's no agreement, if there's not something quick that can be resolved, it's going to get scheduled again. And that's going to be called a pretrial. And if it still isn't resolved there, it's going to go to trial. So you're talking about 3 hearings instead of 2 for what would normally be a dispute. So I would try to remove the dispute, figure out if you can get to the bottom of it. What do they need? Is there something that can be done in letting them out of the lease? Maybe they think that they can't get out of the lease. Maybe they're worried about collections in the future. It really depends on what the landlord wants and what kind of tenant this is. But I'm thinking that somebody who is that far behind or further behind is going to have a harder time also getting funding from public sources or agencies.
Sure, but I assume there's a case-by-case aspect to this, right? I mean, if they're behind 5,000, some tenants won't have a penny.
Right.
Some of them will have 4,200 and not realize there's maybe a deal to be worked out here until that happens, until the eviction actually happens, right? And so you've done this before, and it's just the numbers are so much bigger now.
They are. And I don't know what those numbers are going to be. And I don't know how far behind the line we're going to be, even if filing in those first few days. Does that mean it's a month? It could, with the 7-day notice and then the 7-day adjournment, and then the 14 days at least to the, you know, it's going to keep getting pushed out. So it really depends on I think the landlord's motivation to try to figure something out. And they need to know what the tenant is thinking. Mm-hmm. These are the tenants that I'm hearing about right now that are kind of going radio silent. And
the ones that are behind 5,000.
Behind so far that they're just, they don't want to deal with it. They don't know what to do. Nobody has said anything other than, hey, you owe rent. Mm-hmm. Those are the ones that I think really need to be handled soon. Maybe there's some money available for them now to catch up. Maybe before it's all gone. I don't know, but I think they need to be contacted, and not just by text, and not just repeatedly trying to call them, and you know, which looks like harassment. But maybe send a letter, send a nice letter saying, hey, what's going on? You know, is there something that we can do? Can I help you find some agency money? Mm-hmm. And I think that's something. Correct me if I'm wrong. I had 2 of those webinars with the referee that same week. But I think she even suggested that landlords maybe need to reach out and try to find some of this funding. I mean, if you want to get paid, you need to assist a little bit. And sometimes it's a little bit of phone calling and legwork for a tenant, and they get really quickly overwhelmed, and they don't know the answers either. They might not know what they owe, or they don't admit that they know what they owe. So I think some early settlement is really going to be important, because you don't want to end up in that situation where nobody's talked to each other and you don't have time, and it just gets getting pushed through that bottleneck of cases. Yeah, because we don't know what that other side is going to be. We don't know when it's going to end. So I don't think it would hurt to do this now, even during a moratorium, as long as there's no threat of actual eviction, you know.
Eric, looks like you have a point.
Yeah, I was just going to raise, this is helpful, and maybe this isn't a fair question for you, but I'm just wondering, maybe like your clients, that's something we've been saying on these webinars pretty frequently, is here are some of the resources that are available, and there's even more that's been released now. Ramsey County just announced earlier this week that they've got an emergency rental assistance program that's opening up, and I think you can apply online or via phone. I'll try to put the stuff in the chat on the Ramsey County stuff. And I think, I mean, I think they're paying for like families with kids up to you know, more than 5,000. So there are situations where even if you were behind that much, you could catch up. And then with MHFA coming out with their the state pot of funds that'll hopefully be available through different administrators by the end of the month. I just think getting that communication out there to landlords and to tenants. I mean, we're telling our tenants to, obviously, the folks that are calling us to seek out those areas. And the other thing I'll mention too, just one more point, is we've actually talked, there's some cities that, my understanding, I think Minneapolis has done it, at least earlier on, and maybe some others in Hennepin County were sending out notifications to their landlord rental license list, letting landlords know, hey, you can tell your tenants to apply for Hennepin County emergency assistance, et cetera.
Yeah, and Kim, one of the things that I have been talking about since the beginning, pretty much on a weekly basis, is reminding landlords of what they win if they win an eviction. Right? They don't win money. I mean, they can win money if the tenant settles up with them, but if they really win an eviction, what they get is the property back. And so the really unusual part of this process for our line of work is how far tenants are behind. Most landlords don't let a tenant go 5-6 months. Honestly, that almost never happens in our line of work, but they let them go 5 or 6 months without paying a penny. And they didn't ask for this. Landlords didn't ask for this, but that's the spot we're in. So if a landlord says, let's go to court, let's file the eviction, and they win, all they get is an empty place, then they can chase that tenant for money later in small claims court if they want, or collections. But they're certainly not counting on that money ever showing up in their pocket, versus trying to work out a deal, which might mean they get some money, maybe.
And something is better than nothing.
Right.
It's up to them. And I think they just have to wrap their head around the idea that there might be some loss, or there might be some need to at least reach out and try to come to an agreement, because the court is not really going to solve this problem in any good way quickly if
Sure.
you don't go in with an agreement.
Right. Well, let's go into that second scenario, because we've talked about it a couple times already. Eric, if you could flip the slide. Thank you. So this one's a more, honestly, a more normal eviction, right? I mean, this is sort of going back to pre-COVID-19. The tenant just hasn't paid rent for a month. The landlord goes and files saying the tenant owes $1,000. What would you be telling that landlord? Well, I mean, first of all, would you even tell them to go file at this point? If it's August 13th and the tenant hasn't paid August's rent?
Yeah, assuming it's the day that filings can be done validly, I would say this is probably the situation where you really want to talk to somebody first.
The tenant, you mean? Talk to the tenant first, yeah.
Talk to the tenant first, see where they're at, because that is much more likely to be recovered than those that are so deep in the hole. I'll tell you though, with those really, I've had people get agency funding for $5,000, $7,000 before.
Sure.
Sometimes it takes a variety of people putting it together. There are some that coordinate 3 or 4 different funds from different places, and a really hardworking tenant who is doing the legwork and running around and making the calls can sometimes recover that way. This 1,000 in the scheme of things almost looks like it's not worth filing on the surface. I think it depends on whether it's really only 1,000 or if we are into the following month and things have deteriorated for them. I know most of my clients that I talk to regularly are not wanting to just evict people because they owe a half a month or a month rent. They're doing those payment plans already, where they're getting what they can, and we'll see where everything falls. But I think the more mild situation, even though it's not really acceptable, I think those are the ones where you won't have the tenant burying their head in the sand so much, and they might actually come up with some creative ideas on how to recover.
Because from the tenant's perspective, it's more of a solvable problem versus the giant mountain of money that they owe for several months.
Yeah, that mountain of money is just, it would send anybody off the deep end. I mean, nobody wants to answer the phone or the door or look at their, the text message from the landlord. They don't want to ask for maintenance. Just lots of bad things happen when it gets that bad. And I'm sure there's a lot of them out there.
Yeah. So one thing I've been theorizing about again every week since this all started is that when the doors open for landlords to be able to file, they might do a cost-benefit analysis. Does it make sense for me to file the eviction or not? But once they've done it and they decide to file, I see no value for waiting at all at that point. I think landlords, once they say, I'm going to pull the trigger on the eviction, they're going to file it as soon as they can. And I'm not hoping for that. I guess it's a cynical view, but I think that's what's going to happen. And that's why I'm concerned about the massive number of evictions being filed. Is there a reason that I'm missing why landlords would hold back on filing once they've decided to file?
I think because it's a long line. I think because it's a never-ending schedule. We don't know how they're going to handle that, what I keep calling that bottleneck. And it's going to depend on how many cases there are and how many file immediately. I think if somebody really, that's why it really makes sense to me to try to come up with something creative now with the tenants. Some tenants are leaving now. Some are saying, you know what, I want out of the lease.
Sure.
I want somebody to go move in with. I'll go now, but could you just let that money go? Could you not charge me on my lease? I would hope no landlords would be charging for the entire lease if they work something out. But now is the time. It's going to be really hard to have a settlement conference with a court hearing at the same time online or even in the courthouse.
So because of the unknown date when the evictions will be lifted, let's say we've got a tenant that owes $5,000 using the 1,000 and their lease goes through next summer, for instance, through next March, let's use. And they owe $5,000, but they know the eviction's looming. They're just not sure when. Neither is the landlord. It's a today issue. We don't know if the moratorium is going to be lifted. The tenant goes to the landlord and says, you know what? I will leave. I'll get out of here, but I want you to give me a piece of paper forgiving the debt. What would your clients say to that? I mean, it's not always going to be the same answer, but would they be considering that right now?
I've talked to one or two people who would, maybe not regular clients though, but I've
Okay.
had random calls from people who really just need their property back.
Right. They need to rent to somebody who could pay them.
Yeah.
Right.
So that is an option. Whether they've done it or not, I don't know. I mean, if I have the same tone when they ask me the question, should I pay them to go? Well, you can.
Mm-hmm.
You certainly can. Nothing's going to keep you from doing that. If they accept it and you're willing to pay them, sure, do it. There's also nothing to hold the parties to a lease if they both agree that they want to terminate it. I get that one once in a while. They think because they've got the signed agreement, they're both stuck, and really
Right.
they both want out. And so they could certainly terminate that in writing and be done with each other and move on. So there are those creative things, but they get really stuck with the money and the lease, and just that relationship that just fell apart over a few months of non-payment.
All right. Well, Kim, this is my favorite time of the week. We get to answer questions now. And why I like this so much is because you never really know exactly what you're going to talk about. I'm sure you can see some of these in the Q&A box or the chat box if you have those opened up, but I'm going to ask the questions. Any ones that you don't want to answer, you just say, that's not something I can answer, and I'll answer if I can. But I think most of these are directed at you. So I'm going to start pretty much all these questions that I'm going to read out to you, and then we'll see what you think. So first off, we have a question from, I think it's Manju. Due to COVID-19, can the landlords provide termination notice by email, iMessage, and a phone call to the tenant? Additionally, paper copy by mail, which may get delayed during this situation. Okay, that's a hard one to translate, and that's people are submitting stuff on the phone a lot, and so it doesn't really flow English-wise sometimes with proper grammar and syntax. But let's start with this. Can a landlord provide a termination notice right now, in your view?
I don't believe so, no. I've been advising, no, you can't.
Okay, and I think that's an easy question under the August 4th rules for sure, where it really does get clarified in my mind. And Eric, just so you know what I'm doing, I'm staying with the stuff that you had put in the questions submitted from the chat box, and then I'll go to the Q&A after that. So you can clear them out of the chat box as we're going. This one's from Gabriel. I rent a home, and the homeowner is selling the property. My lease ends March 31, 2020, or ended, I guess. I understand they can't kick me out without damage to the property, and they can't raise the rent to attempt to get me out. What, if anything, can I do to stay in my home if they claim family are moving into the home? Okay, so Gabriel's bringing up one of the new August 4th exceptions. So he's saying there's no damage. They can't, he's wondering if they could raise the rent to try to chase him out. But his lease, I assume he's month to month now since it ended March 31 of this year. So what do you think about the family exception? Can you sort of walk through how you think that would play out, the family exception?
Well, and I really didn't like that family exception in the new order. I don't know where that might have come from. It seems like it would be a rare circumstance, but it's something that someone could take advantage of and say, hey, I'm going to be moving in here, pretend that they're moving in. It does include a requirement that the property owner actually move in. I haven't had anybody ask that question yet.
Okay.
I think he's stretching for something that hasn't happened yet, perhaps.
Well, sure, he's theorizing kind of a worst case scenario. We get questions like that a lot, but yeah.
The question was that notice had already been given?
Well, I think he's worried that if they claim the family, to start with, I don't think a landlord can do anything with this until August 4th.
Correct.
I don't think they can give a preemptive notice of August 5th, I'm moving in. I don't think that works.
Right.
But anyhow, I think on August 4th, what Gabriel's concern is the landlord gives them some sort of notice saying I'm moving in or my family member's moving in. Is there anything he can do to protect himself from that as a tenant? Is there any step he could take?
Well, I think it would really fall under an eviction for holding over after notice if he doesn't leave. So those are not allowed right now.
Sure. Well, yeah, I mean, the landlord would file the eviction for holding over after the family notice is given. He could, of course, defend the case saying, oh, the family's not really moving in or they're making all this up. But then he'd risk having an eviction on his record as well.
Well, yes.
Yeah.
What do we think the proper notice is after August 4th for this?
Yeah.
I think that's the question, is
Yeah.
we're getting ahead of an order that is not in effect yet, and we don't really know if that's what the plan is, and we can't file, if for example, the moratorium was extended, the peacetime order was extended, they wouldn't be able to file an eviction anyway for the holding over because they wanted to move in.
Well, I think they can file an eviction for the family exception because it's one of the exceptions. They'd have to give the 7 or notice period notice first.
They'd have to give the set. Okay. I see.
Sure.
I see what you're saying. I can't read the question, so
Yeah.
I
Yeah.
don't see it.
Well, Gabriel, I'm not sure that we can give you a thorough answer. A couple of reasons why. The law is, the executive orders in parts vague, and in other parts it's confusing. So we're not sure how a court's going to rule on this until a court rules on it. And I know that's not a satisfying answer, but anything else right now is pretty much an educated guess, which I think we both gave you our best versions of that. But anyhow, let's go on to the next question here. I'm going to skip one because I just don't think it's too specific for what we're talking about here right now. This is for you, Kim, so I will be quiet. From Linda, why is non-discrimination treated as a mandate when it is not mandated? The landlord can raise their rent $10 over the Section 8 ceiling anytime and wiggle out of Section 8 Kim's status. By the way, she says, thank you for doing this. I appreciate hearing your point of view.
Oh, that's
It's a hard question along with a thank you.
It is a very hard question. I'm not exactly sure. Are you talking about a retaliation there?
Well, I think it's either retaliation or to get them, the landlord hoping to get themselves out of the Section 8 parameters for fair market value. So they would effectively be able to say no to Section 8 without saying no to Section 8.
Yeah, and I don't run into a lot of people trying to get out of Section 8 as far as landlords. They're not looking to do that or manipulate the system. I can't say I haven't seen it in the past. I'm pretty careful though with whom I will represent. I like to know that they're following some rules, that they're not doing things like that. So I don't think I can answer beyond that. I just have not run into that sort of manipulation in that way.
So this isn't the question that they're asking, but it's something that I've been thinking about a lot, which is where rents go at this point. I think there's a chance that rents are going to actually stabilize and in some cases maybe even go down versus the steady march up that we've seen over the last 8 to 10 years. Have you heard anything from your landlord clients about that question?
I haven't heard that exactly. I have heard speculation about the market in general, that the market is maybe bound to for a bubble burst again, maybe something like we had in 2008, 2009. I think we won't know until we see what happens with foreclosures after this either. But I don't see my clients escalating rents or talking about being worried at the moment about the bottom dropping out. But I could see if the values come down, maybe there's a little bit of a struggle, but we've got a shortage in the Twin Cities anyway of housing. So I'm not sure.
Fair enough. Okay. Another question. This one says it's for me, but I don't think it's needed to be directed at me. Can Minnesota tenants ask for jury trials? I guess a landlord could too as well. When there's an eviction post-COVID moratorium, does asking for a jury trial give a tenant more time before they have to leave or time to negotiate to stay? So this question, I'm sure, is hinged on what people have been reading online, where other states, lawyers, tenant advocates, where eviction doors are open again, they have been asking for jury trials. In some cases, again, a cynical landlord lawyer view would be they're just trying to extend the time that the tenant gets to stay. What is a jury trial by a tenant if they demand a jury trial in an eviction in Minnesota?
I don't know if it will buy them extra time in this situation. And I think the question is, what is going to a jury? What is going to trial? Because there are limited grounds. So if it's just to, is it a valid defense? I think if we're dealing with Hennepin County Housing Court or Ramsey County Housing Court, they're going to deal with it pretty efficiently, and they will listen to the tenant. As far as the jury trial, I suppose that it's a right and it will get it'll push it out maybe further, but they're already getting a lot of time. So I have a struggle with that one as far as if we're out 4 months already, what are you trying to do? You know,
Sure.
how many months do you need if you're already 5 months behind?
Well, I get your point, but what would a jury trial, I mean, just looking at this completely cynically, what does it buy a tenant time-wise? I don't know that it buys them that much time to ask for a jury trial in Minnesota.
No, I don't think it does. They put it together pretty quickly, and you still have to have a trial within a certain amount of time that you can put it together. I think the question for any tenant wanting a jury trial is why? I mean, who's going to represent the tenant in that?
Well, they could represent themselves
they could represent
badly.
Themselves, exactly.
Right.
Exactly.
Sure.
I mean, they're going to have that challenge, and now they're going to have a jury watching it too. So I'm not sure that it's even advantageous if it dragged things out a little bit.
Sure. The last question, then I'm going to jump over to the Q&A section. And somebody's clarifying Manju's question. I understood Manju's question to be wanting a digital notice in addition to a paper copy, since there may be delays with regular mail right now. So, okay, I think they're opening this up. A notice to vacate from a landlord to a tenant, does that have to be on paper? Or can it be an email? Can it be a text? What have you seen with your practice?
I usually advise doing it all, and it can come down to what the lease says. Sometimes the lease will say the communications can be by email, and that's fine. A lot of the standard leases say notices provided to, and they give a street address. So I think in that case, I would say that notices need to be by regular mail. So I would usually say do regular mail, do certified mail, and if you want to attach a copy in an email, do it that way.
What if it's just an email? Is that enough if the lease is silent on that in your view?
I don't like to see it. I don't like to run into a question of holding over and invalid notice. So I prefer mail. If I'm doing notices for my client, I do mail and certified mail. And at least I know one gets there.
And these are questions we get a lot on our hotline. What about a text? A text notice from a landlord to a tenant to vacate. What do you think?
I don't like texting at all, landlord to tenant. I don't like it at all. And
well, that wasn't the question. What's a court going to say?
You know, if the texting makes sense, maybe that's a written notice. I don't think that they'd be precluded from that, but I can't tell you how many times somebody's handed me a cell phone or printed out some text messages and said, here, read this, see, it makes sense. And they say, no, it doesn't. It's all out of context. There's no punctuation.
You can't tell dates frequently. It's really difficult to tell what the date it was, yeah.
Can't really say that I'm seeing it the same way as that person is who's giving me the text messages. So I really try to avoid that, but I think an email with an attachment of correspondence is okay, kind of like we do as attorneys at times. But if the lease is clear on it, that's much easier. That's an easier answer. But I think a lot of landlords will automatically put in a street address for their notices. Mm-hmm. And I think that answers the question that it should probably be by mail.
Right. Well, I think you're right when the tenant's giving it to the landlord, but this question is a landlord giving the notice to the tenant. So it usually doesn't say the notice has to be sent necessarily to the tenant's place. One of the things that I always ask about is what's the email relationship? Is this the first email you've ever sent the landlord or they ever sent you? If you've got an ongoing back and forth, I think it really legitimizes giving a notice in an email and really does in a text. If you've never gotten a text before from some number and you get a text, it's like, who is this? I don't.
You don't know. Yeah.
Right, exactly. Yeah.
Yeah, I think you could use email in that case, but my problem with some of those emails is they read like text. They start to get really casual and you can't tell what's going on. And pretty soon you've got this big chain of, okay, well, what about this date instead? And it's hard to tell what's going on because they're mixing it up. And the easiest thing to me is just send a letter and send it 2 ways, either way, from either direction.
Okay, we're going to jump into the Q&A session. We have
I think one quick thing. I think we can all agree that you shouldn't do notices by Snapchat, right? Because the entire purpose is that it goes away, right?
Okay, there's consensus on that one.
Right? Okay, I just wanted to get agreement.
Yeah, we have about 20 minutes to go, and we still have 7 questions that I see, and maybe a couple more that I'm not seeing in the chat. But let's go through what we can. Since Section 8 funding was continuous from HUD during COVID and still is, Kim, do you envision landlords looking more kindly upon doing business with HUD and accepting vouchers in the future?
I didn't think they were unkind in the first place. I know there are some out there that are, but
Mhm.
that's not my experience. So, and
It's not your clients is what you're saying.
it's not my clients.
Got it.
Yeah.
Well, obviously there's some clients because of a bunch of landlords went to the Supreme Court of Minnesota to try to fight over this. So there must be some landlords that don't like that notion.
But now that we've had this happen, maybe that's where they'll realize that that's the steady rent stream that's going to come in.
Sure, right. We talked about that earlier about how we're seeing less no Section 8 here right now because of the COVID-19. Okay. Okay, so this is a little bit, do you have the Q&A in front of you, Kim? Do you see these?
I do now. I was
Okay.
in this before when you were on the other, so I really
Okay.
couldn't see.
Oh, I'm sorry, but you're able to follow along. This is a long question. It's a lot easier when you can follow along, but I'll say it out loud. All right, small percentage of bad actors. As a Section 8 voucher holder, I estimate 85% of HUD subsidized residents are good, reliable, long-term, and safe tenants. I think it's a lot higher than that, Lynn, but okay. Why, in Kim's opinion, does that remaining percentage, whether it's 5 or 15%, give everyone a bad name? And following up, when landlords are given rehab funding and repair cost reimbursement programs for those few bad actors doing damage, these landlords seldom use those funds, if at all. Okay. Why don't landlords use the rehab funds? Would they rather complain than foster the programs? That seems to poison the pool. Okay, there's a lot there, but let's start off with the stuff that's a question here. This is a fair question, actually, because I can tell you I've given landlord speeches before, and I'll ask, do you accept Section 8 vouchers? And, you know, there'll be a pocket of the room that says no. And I'll ask them why. And a lot of times the answer I'll get is, I had a Section 8 tenant once, this happened, and I said never again. And usually the description they give is like some destruction of property or damage to property. And then I ask the question, the follow-up question, which is, have you ever had a non-Section 8 voucher holder cause damage to your property? And they say, well, yeah, but you still rent to them. Well, yes. And so I think that's what Lynn's getting at here is, why are landlords, and I know you're talking about your clients aren't these landlords, but obviously there's some that say no to Section 8. So why do you think they say no to Section 8 or have said no in the past?
I think there's just a mischaracterization of Section 8 tenants, of who they are and what it's about. I think in some cases it might be the paperwork that you're entering into a different agreement that might be a little harder to get out of. But, and I know what this question is talking about, and I have seen this. I just don't think I've seen it in the last few years, and certainly not with anybody I'm representing right now. I don't think they are characterizing Section 8 recipients so generally. And I think it's the flip of that, what we talked about earlier, that it's reliable income. You've got a housing worker, you've got somebody sort of playing the middle. I don't know why, you know, people make assumptions so about a lot of things, and maybe this is just one of those that has gotten pretty deep with maybe even some level of discrimination. I don't know.
Okay. Well,
I don't represent those people.
Sure. And look, you're a private attorney. You can say no to clients, right?
Yeah.
And I'm sure you have turned down clients before that wanted to hire you. Maybe not for this reason, but for whatever reason. And so you're allowed to pick and choose which clients you work with. You're not a public defender where they get assigned to you.
Right.
Yeah. Okay. Let's go on to a question from a landlord. I am a landlord with a tenant on a month-to-month lease in a single-family home. I've given my tenant notice, including a ROFO. I don't know what a ROFO is. Do you know what an ROFO is? I'm not sure I know what that is. Anyhow, I've given my tenant notice that I plan to put the house on the market for sale September 1st. The house goes to market and a new buyer buys the home. Does that buyer have the right to terminate the tenant's lease? Okay, again, the tenant is month-to-month. The owner wants to sell and wants to know if the new buyer can terminate the tenant's lease. So let's do it two ways. Let's do a pre-COVID-19 answer and a current COVID-19 answer as well. Go ahead.
Pre-COVID-19, I would say they need to give notice to vacate, proper notice to vacate, with one full rental period plus a day. If the new owner took possession on September 2nd, let's say, assuming rent's due on the 1st, they could give a notice for the end of October. That new owner could, once they took possession, right? That's your month and a day analysis. Okay, that's pre-COVID-19. Right now during the eviction moratorium, what's the answer there? we can't do a notice to vacate. You could probably see if you can convince somebody to move out, do kind of a cash for keys thing, try to negotiate something for a move out. I think what I usually run into with this, because actually somebody just called me on this, something similar. A lot of times with that single family home, when it gets sold, the buyer wants to move in, and their financing is connected to the idea that it's going to be their homestead immediately. So unless it's an investment property, they might have an issue with some kind of mortgage fraud problem. So really the best situation is that notice be given and the tenant be out before the house sells, because the lender is going to look at that and see, wait a second, there's a tenant in here? You can't, this isn't an investment property. We want you to be living here. And they run into that. And I've had it happen where they get into the transaction, they think they're going to get to a closing and suddenly find out, wait a second, we can't just tell these people to leave. We can't just terminate the lease because it's sold, because the lease and the tenants do go with the property. So the new buyer gets the tenant and they get the lease, and then they'll have to deal with it.
But the new buyer might be able to rely on that family exception though, if they take possession and they could use the.
They might, and maybe that's the situation, but now who gives, well, they'd have to buy it first.
Right. I think the new buyer, the new owner would have to take possession, say, I'm going to move in or my family member is going to move in. I don't think the old owner can do that if they weren't going to take possession themselves.
Right. And then I think I still run into that problem with some financing saying, no, it can't be occupied by a tenant right now. And whether they tell them that or not, sometimes it slips out.
No, I appreciate the kind of the thought process you walked through there. That was interesting. Okay, next up, regarding this morning's Supreme Court ruling, if Section 8 public assistance does remain a protected class, which is effectively what Minneapolis is trying to do, make Section 8 a protected class, what does that actually look like? Will this prevent landlords from discriminating on the basis of income, as many tenants who have 2 to 3 times the income would not qualify for public assistance programs? What are your thoughts there?
Well, I think it does. Yeah. You know, that's the way it used to work. Wasn't the public assistance exception only effective maybe back in the early 80s? Before that, it was different. So I'm thinking.
I'm sorry, you're asking about the state law making receipt of public assistance a protected class?
Well, public assistance has always been a protected class.
Right, before this ruling today, yes, that's right.
Section 8 was not part of public assistance, and that was
a Court of Appeals decision from
many years ago,
like 2011, yeah. But I think they're asking, I mean, look, this is a modern question, it really is. We have these income requirements. I'm sure many of your clients have income requirements that they have in place. You know, you have to have 2 or 3 times the income. No. We have the Minneapolis ordinance that just went into effect in early June, which has to be considered as part of this. But I think what this is asking is, does this stop a landlord from using 3 times the income because Section 8 vouchers are a protected class? I think that's what they're asking.
I don't know the answer to that. I think it could be, they're going to have to find a balance, aren't they? Looking at what they might get for Section 8 is going to play into it.
Sure. I'm not, and Eric, you're welcome to jump in on this.
Income itself isn't a protected class.
Right.
It's public assistance, and it's the Section 8.
That is my first take on this, is that this is just, what this is stopping is, to make it really followable, is where a landlord puts on Craigslist, you know, no Section 8 allowed, which a lot of landlords do. I mean, if we went on Craigslist right now and just looked around the metro area, we'd find probably hundreds of those where it says no Section 8 allowed. A landlord clearly can't do that in Minneapolis under the ordinance. A harder question is, can they use an income requirement that effectively would stop Section 8 tenants from applying? And I don't know that that's as well covered by the ordinance. Eric, do you have any thoughts on this one?
Well, I don't think so. I mean, Minneapolis already has you can discriminate on 3 times the income, but you just have to provide the tenant the opportunity to demonstrate the history of rent payments. I'm not sure that this really necessarily touches just touches it broadly. I do think it does cover the instance where, and this doesn't happen that often, but we definitely did see it when we used to do our Section 8. So for years we did a survey of landlords throughout the metro area, and just before Minneapolis enacted this, we did a survey. It was actually part of some of the court cases. We did a survey in Minneapolis, and there are some landlords who will say they take Section 8, but then they will have an income requirement that's based on the tenant's portion of income. And so, yeah, it sort of effectively makes it so that no tenant with public assistance could. And is that the question that this is getting at?
I'm not sure. And
yeah.
I mean, I read this ordinance, the last time I read it was when we were working on an amicus brief for the Supreme Court on the case that was heard today. So it's been whatever that is, 5 months, 7 months. Time seems irrelevant anymore. So I don't remember when we worked on that last. So I don't remember all the details of it, but I do
think that on this small point, I don't know broadly, but I'm pretty sure that if you're a landlord that has that practice where you're saying, oh yeah, for purposes of the ordinance, I take Section 8, but my income requirement for you getting in here is 3 times your, based on your income, not based on the tenant rent also, because it ultimately just excludes people, and it would seems like a clear violation of the ordinance.
Well, let's because we're not getting the certain answer here. Let's jump ahead with the few minutes we have left and answer a few more of these questions. Kim, if a tenant is behind by $5,000, but will be eligible for COVID grants of around $5,000, will landlords accept promissory notes agreeing to wait for money from a community service program who will send the check directly to the landlord? Will they wait for that? And it's not, I mean, we could talk about emergency assistance or all types of different programs, but how does that work when an agency guarantees money to your clients? Is that usually enough to get them to say, okay, this is real?
Yeah, it is. Yeah.
Okay.
The problem, I think, comes into play with what is a guarantee, because I've had agencies tell me, well, we don't really give a guarantee. We might give you a letter that says that we think we're going to get these funds. So there's a matter of trust there, but I will often do settlement agreements that say, look, I don't care where the money comes from. You're gonna, you've got a payment here, and then you've got this lump sum payment maybe a month from now that should give you time to find those funds. And it could be any agency guarantee or emergency assistance. If it turns out to be real money, that's fine, or a money order. It's just, it wraps the whole thing up in that settlement agreement that says, yes, we will work with this. And then of course, the landlord needs to be willing to talk with that agency or whatever it is, because they usually want some confirmation, some lease information. They need to know the landlord. But yeah, we do that pretty often, actually.
Sure. Oh, we got a follow-up from the person that was asking, the ROFO is a right of first offer.
Oh.
Which they say is common in commercial real estate. I don't do commercial real estate at all. And it's not common in our line of work, landlord tenant residential work. Occasionally we'll see contract for deeds, rent to buy deals, which are really hybrid home purchasing deals more than they are leases generally. So right of first offer. So that was our question that we got that was about the sale to the next person. I don't know that right of first offer changes the answer at all that we gave earlier. Yeah. Okay. I appreciate whoever wrote that in. It was anonymous. I appreciate you letting us know what ROFO, because we both learned something today, but we're just not used to that phrasing. Okay. Last question that I see that's current is, so there's some COVID relief where the landlord can't apply, but the applicants can have higher income than usual. Can a landlord guide a tenant to these local human service agencies where even something like the tenant might be able to get food stamps, so then they'd have some money freed up to buy food, so then they could pay their rent? Is that okay for a landlord to try to steer a tenant towards non-rent resources that are out there? Or would you say that's a bad idea for a landlord to do that?
That's a really interesting question. I feel like it's got some sort of a backstory to it. Like maybe somebody felt that they were being steered. I would probably say, no, that's not your job, but you could tell them where it is. I mean, those agencies aren't really a secret. So I don't know what the landlord would think. Is this a landlord who's saying, well, if you go do this, you'll have that extra $300 and you can pay me my rent? I don't think that is a good idea, to tell somebody how their food money has to get used.
Right. Well, what I think the question is trying to get to is it okay for the landlord to just throw out a broad resource net? You know, these are things that you might want to look into that you might be available. We've talked about this before. Landlords and tenants might not think of this in this way, but in many ways they are in this together.
Yeah.
There's a giant debt owed. The tenant would love to pay it if they could, whether it's their own money out of pocket or some agency paying it. The landlord certainly wants to get paid. There's probably a common interest here. And so if the landlord knows about stuff, and I will go talk to various groups, and I'll mention that, you know, I had a tenant the other day that I talked to on the phone, had an eviction filed against them. I told them about emergency assistance and they just didn't believe me. They had no idea what emergency assistance was. What do you mean somebody's going to pay my rent? What's the catch? Well, you couldn't have gotten it within the last year and your income has to qualify. And I don't understand. Is this a loan? Do I have to pay it back? It's a loan, right? And it's just, they have no idea that something like that might exist. There's no intuitive reason why you'd think emergency assistance exists. If you're in this world, you of course know it exists. But a landlord's saying, you know what? You might qualify for food stamps. I'm not sure that that's a bad idea. And I don't think there's any rule that says that they can't tell a tenant, hey, go out and get all the resources that are out there.
No, the broad net of resources is great. I think every landlord should be looking at that right now, that very thing. Here are the resources. Here's what you can do. Maybe this one will work. Let me know if I can do something. If I need to talk to them and verify your rent or your lease or what you owe. Yeah, I think that's a great idea. I think the framing of the question with the word steering makes me a little skeptical about what might a landlord be trying to do with that food money.
Hey, that's my fault. I threw the word steering in there. Lynn asked that question, and she didn't say steering. I did, to sort of summarize it. But look, one of the things you just brought up is something that a landlord can give a tenant in the assist department, which is in emergency assistance, the landlord has to fill out a form saying, this is the tenant's rent on a monthly basis. This is how much they owe right now, which is basically saying, tenant, if you pay me X by this date, you're current, right? But a landlord needs to fill that out. And if the landlord simply refuses to fill it out, the tenant's never going to get the emergency assistance. So the landlord's saying, I'm happy to help you fill out whatever paperwork, because there's usually paperwork required, is something a landlord can offer that is a meaningful offer. Tell the tenant, hey, I'm going to be on your team to make sure you can get whatever you can get out there.
If they want to get paid, that's what they've got to do. I do remind my clients of that when I enter into a settlement agreement that has a guarantee. The first thing I say in the phone call is, okay, you agreed to a guarantee, so if anybody calls you, you need to cooperate. If they send you paperwork, you need to do it. I have not had problems with mine doing that. If I did, I probably wouldn't represent them though.
Sure. Well, wow. Hey, look, it's 3 o'clock. Wow. The time just does fly when we do this. That was fascinating though, Kim. And I really appreciate you taking the time to offer a landlord attorney perspective. And I know that whenever things open up again, it's going to be weird and brand new. I hope that you are able to give your clients what they need to proceed and hopefully work out as many deals with tenants as possible, because it's going to be just a deal factory, I'm hoping, versus an eviction factory.
I think it needs to at least start there. Yes.
Yeah.
Trying to settle, trying to come to agreements, some kind of mutual terms. Yep.
Thanks again, Kim. Good to see you.
Thanks.
All right, thanks everybody. I did put the registration for next week in the chat, and it will be up on our website hopefully later today or tomorrow, as will the recording of today. And so hope you all have a good rest of your Wednesday. Thank you all, and thank you, Kim.
Thank you.